I'm going to speak about software AI and legal protection with a specific focus on the right of communication to the public and the making available right. This is a short diagram of the presentations of the presentation. I'm going to speak on the right of communication to the public and making available right regarding software protection by making a reference to Article 8 of the WIPO Copyright Treaty, Article 3 of the InfoSoc Directive. This is the Information Society Directive. And also I'm going to make a reference to Directive 24/2009 on the legal protection of computer programs. Then I'm going to give you the exclusive rights, short presentation, the exclusive rights of the software right holder. I'm going to refer on how software program can be communicated to the public. After that, I'm going to make a reference on AI elements and software protection, meaning what is protected and what is not protected, how it is protected, the material that is protected, actually. I'm going to make a brief reference to patent protection for software by making a reference to Article 52 of the European Patent Convention. And in the conclusion, I'm going to focus on AI software applications in online periodical publications, and especially in the creation process, in the process in the phase for the personalization and engagement, for distribution and audience growth, and also for efficiency in monetization. So let's start this presentation. The right of communication to the public and the making available right subject matter on the internet normally takes place on demand, pulled away from places and at a time chosen by the user interactively. Such use of copyright subject matter on the internet is carried out to the public in the sense of the copyright legislation. The public is approached only successively, in the sense that individual members of the public do not access particular work or other subject matter simultaneously. As of 1987, the Austrian Supreme Court has made clear that such successive public is deemed to be public within the meaning of copyright law. And this is the case of Sex Up in 1987. The WIPO Copyright Treaty provides for the communication to the public right in the clause of Article 8. I'm not going to read the whole article because the presentation is going to be shared, so the readers will have the time to read it. According to Article 8 of the WIPO Copyright Treaty, authors enjoy the exclusive right to authorizing any communication to the public of their works by wire or wireless means, in such a way that members of the public may access these works from a place and at a time individually chosen by them. The right of communication to the public, according to Article 8 of the WIPO Copyright Treaty, does not extend to the traditional rights of performance and recitation, according to Articles 11, Paragraph 1, and Article 11, Paragraph 1 of the Berne Convention. Also, Article 8 of the WIPO Copyright Treaty does not extend to the public display of works by visual arts. In addition, it is understood that the mere provision of physical facilities for enabling or making communication does not in itself amount to communication to the public within the meaning of Article 8 of the WIPO Copyright Treaty and the Berne Convention. Article 3 of the Information Society Directive is one of the centerpieces of this directive. We're talking about Directive 29/2001 on the harmonization of certain aspects of copyright and related rights in the information society. And this directive and this directive aims at implementing Article 8 of the WIPO Copyright Treaty, as well as Article 10 and Article 14 of WIPO Performances and Phonographs Treaty with regarding to the making available right. Article 3 of the Information Society Directive adopts a broad concept of Article 8 of WIPO Copyright Treaty and thus covers all traditional forms of communication to the public characterized by a distance element. The term communication to the public encompasses all forms of communication where the public is not gathered at the same place and time, and also includes broadcasting by wire or wireless means. The exclusive right of communication to the public is limited to communication characterized by distance elements and thus does not extend to the traditional performing, recitation, or display of works for a public gathered simultaneously at a place. This follows from Recital 23 of the Information Society Directive. Article 1, paragraph 1 and 2 of the Information Society Directive deals with the specific right of making available under the right of communication to the public. The making available of copyright material is characterized by the distance element, as I said, and may be carried out by wire or wireless means. Thus, the term making available is to be understood as technologically neutral and applies irrespective of whether the upload to the network or the access by the user is carried out by means of a conventional telephone network or by mobile phone network or through dedicated internet network. The public need not necessarily be addressed at the same time. The making available does not presuppose the provision of a design program. The public is addressed accessibly, and the access to material made available is being carried out individually. The making available is accomplished in providing the possibility of interactively accessing the work or other subject matter offered by a content provider in the network. The making available is completed by the mere provision of the material on the net. It is not necessary that members of the public, in fact, access the copyright material. The transmission of the copyright material is not governed by the making available right. If the copyright material or other subject matter is not accessed by the user at a time individually chosen by him, but rather is transmitted to him over the net on the initiative of and or at the time chosen by the sender, the making available right does not apply. Qualifying the making available of works or other subject matter on the internet as an act of broadcasting is opposed because broadcasting conceptually requires the simultaneous addressing of the public on the ground of a one-to-many relationship, which is not the case when copyright subject matter is made available interactively on the internet. The decisive criterion for the distinguishing of making available right from the broadcasting right is that the user, in the case of the making available right, may access specific work or other subject matter whenever he decides and from whatever place, whereas in the case of broadcasting right, the access to the public work, the access to a specific work can only be carried out simultaneously with its transmission. In the case of simulcasting, where broadcasts emitted by broadcasting organization are simultaneously communicated over the internet, this is regarded as broadcasting rather than as making available. The same holds true for webcasting, where independent programs specifically created for the internet are transmitted over the internet. Also, the near video on demand service is to be classified as broadcasting rather than as making available if a program is offered. In the case of podcasts, copyright material from whatever source is made available to the public upon the initiative of the user at the time of his discretion. This case is to be classified as making available to the public, where the user, by means of a special search program, selects the material to be listened or viewed according to personal preferences from a database. This is to be regarded as making available right. Article 3, paragraph 2 of the Information Society Directive posits that the making available right is granted to performing artists, phonograph producers, producers of the first fixation of films, and broadcasting organizations. Article 3, paragraph 3 of the Information Society Directive explicitly stipulates that the right of communication to the public, including the making available right, as provided for in Article 3, paragraphs 1 and 2 of this directive, must not be exhausted by any act of communication to the public or making available to the public. The principle of non-exhaustion is emphasized in Recital 29 of the Information Society Directive, since the communication to the public right, including the making available to the public right, is considered to be right related to a service rather than right related to the merchandising of tangible goods. Neither Article 8 of the WIPO Copyright Treaty nor Article 3 of the Information Society Directive do they circumscribe the notion of the public. However, at least in the context of the making available right, in both Article 8 and Article 3 of the Information Society Directive, It is clearly stated that the public must not necessarily be gathered at the place to be addressed simultaneously. This also applies to any other form of communication to the public. Thus, the successive public is relevant with regard to the right of communication to the public. Taking into account that it is in the author's legitimate interest to control the exploitation of his work, except where this takes place in a merely private circle, the term public may be circumscribed as any use made by copyright subject matter, which is not a private one. Private is a use of copyright subject matter, which is within the circle of close relatives, close friends, or close acquaintances. The Court of Justice has pointed out in its Rafael Hoteles decision that the term public was not left to the national legislation's discretion, since the provisions of the Information Society Directive must be given an autonomous and uniform interpretation throughout the community. In consideration of recital 23 of the Information Society Directive, the notion of communication to the public must be understood in a broad sense in order to achieve protection at on a high level. Recitals 9 and 10 of the Information Society Directive explicitly refer to such a high-level protection. The notion of the public in the Information Society Directive is to be interpreted according to the identical rules for the interpretation of the notion of communication to the public. In principle, the fact that whether a communication takes place for economic or commercial advantage is not decisive with respect to the question whether communication is directed to the public or is deemed private. Also, the term public does not necessarily require that an act of communication is of a point to multi-point nature. The transmission of protected material from point to point is to be regarded as communication to the public if the persons communicating are not privately interconnected with each other. Under the European law, software enjoys special legal protection through the distinct framework within copyright law. Directive 24/2009 on the legal protection of computer programs, codifying Directive 2050 of 1901, is the cornerstone of EU software protection. It harmonizes the copyright protection of computer programs across member states and establishes that computer programs shall be protected as literary works within the meaning of the Berne Convention. So, for software to be protected as literary work, it must be an original intellectual creation of its author. That is, the author must have made free and creative choices during development of the software. Renowned cases which have confirmed the protection of software as literary work are the Court of Justice cases known as Infopack case, or also known as the BCA case. The European law protects the expression of a computer program, which means that it protects its source code, its object code, and possibly its design and preparatory material if they are sufficiently detailed to lead to a program. The user interfaces are protected only if they reflect the author's own intellectual creation. The European law does not protect by copyright the ideas, the algorithm, the programming languages, and the functionalities of the software. Under Article 4 of the Computer Program Directive, the software copyright holder has the following exclusive rights. The reproduction right, which pertains to the permanent or temporary copying of the source code or object code in whole or in part, and does not allow without the prior consent of the software code author the loading, displaying, running, transmission, or storage of the program, even temporarily in the RAM memory. The adaptation right, which does not allow without the prior consent of the software code author the translation, adaptation, arrangement, or any other alteration of the program and the reproduction of the results thereof. The distribution right, which is the author's exclusive right to authorize or prohibit any form of public distribution, such as sale, rental, lending, etc., of the program or copies thereof. And the communication to the public right. This right is not explicitly listed in the 2009 directive. However, it exists as an exclusive right to the software code author under Article 3, Paragraph 1 of the Information Society Directive when the program is made available over the network. Now, the question is, how can a software program be communicated to the public? it can be communicated to the public through at least the following ways. Through web-based access to software in the software as a service model. In this communication to the public of the software runs on a provider servers, but users interact with it remotely. Through streaming or remote execution of the software, through this model of communication to the public, the software never leaves the provider server, but the output of its reproduction is transmitted to users who make use of the software streaming or its remote execution. Communicating to the public of the software occurs through an on-demand transmission of the software's performance. Through publicly available demo or beta testing of the software. An example of this way of exercising the communication to the public right regarding software is the releasing of a beta version of an application for free download or the streaming via public website. Through the uploading of mobile apps in order to be distributed via app stores. For example, the uploading of an app to Apple's App Store or Google's Play for public download is an exercising of the communication to the public right of the software and specifically the making available right of the software. Through the embedding of integrating or integrating of software code in public web pages. For example, the embedding of JavaScript libraries hosted on a public website communicates the software to the public when the website automatically loads and executes the embedded JavaScript libraries. Through the provision of publicly accessible APIs that execute proprietary software routines on its servers. In this communication to the public, users send requests and receive outputs generated by protected software code. This is a remote use scenario akin to communication to the public. And through corporate intranet accessible to external users. When a business provides external consultants with login credentials to access its internal software tools, this limited access can constitute communication to the public of a protected software. On the level of AI applications, most, if not all, come down to predictions made on available information and software that has been trained to make these predictions. Other forms of AI applications are search machines that try to find a certain optimal result within a large number of possibilities. Both forms of AI applications can be combined. The type of AI application that is most commonly used nowadays is machine learning. Machine learning is a way to apply statistical models and pattern recognition to large amounts of data in order to make predictions regarding similar but not new situations. At the core of machine learning applications are one or more training algorithms, training data, and the model architecture. The developer of machine learning leverages on the model architecture to teach the AI application via the training algorithm using the training data. The result of the teaching process is a trained model that can be used as AI application to fulfill a certain task. Therefore, common elements of AI applications can be algorithms, mathematical models, the framework in which the AI application is created, trained, and evaluated, the ways and biases which influence the way in which information moves from input layer to the output layer, fitness functions and other evaluation mechanisms which set the parameters for the evaluation of the AI application output, training data, documentation, the output of AI application. Regarding these AI elements, the question is what is protected and how it is protected. This table gives you the answer to the question. For example, source code and object code, there is copyright protection as software from both directives, the Information Society Directive and the Computer Programs Directive. Regarding algorithms and mathematical models, under condition, there is protection through patent or trade secret legislation. Regarding training data, there is copyright protection only if there is originality in this data. Also, there is copyright protection as a database only if the data is formed into a database. And then we have also the sui generis right. Regarding ways and biases, under conditions, there can be protection through trade secret legislation. Regarding fitness functions, under condition, again, there can be protection through trade secret legislation. Regarding the output, if this is protected by copyright only if there is human intervention in the provision in the creation process. If there is no human intervention in the creation process, then there is no copyright Europe-wide, with the exception of the British, as it is known. Documentation, there is copyright protection only if there is originality in the documentation. Now, let's talk about the issue of patent protection for AI software. The European law is that the rule is that there are for programs of computer there is no patentability. There are the provisions of Article 52, paragraphs 2 and 3 of the European Patent Convention, according to which it cannot be convention. I mean, there is no possibility for an invention in the meaning of paragraph 1 for computer programs. However, with respect to computers, the case law of the European Patent Office makes it clear that the exclusion of Article 52, paragraphs 2 and 3 of the European Patent Convention does not apply when the computer program has a technical character. This is actually stressed in the guidelines for examination, Part G, Section 2, paragraph 3.6. This limitation of the exclusion is the needle eye through which software developers try to squeeze their products to obtain patent under the European law. By simply replacing a process or the acts of a human being with software in an AI app, which are not considered to be technical, the software and the AI app are not patentable because their invention is not considered to have a technical character. As the European Patent Convention guidelines and the European Patent Office case law set it out, further technical considerations beyond merely finding a computer algorithm to perform a task are needed. A program of a computer may have technical character if it is capable of bringing about, when running on a computer, a further technical effect going beyond the technical effect that always occurs when a computer program is run on a computer. For example, such further technical effect may occur in the control of a device in such a way that the program has an effect on the internal functioning of the computer itself, which is something that can happen in the case of AI software. The main difference between ordinary software programs and the AI application is the higher complexity and the fact that the value behind the AI application is not just the code or in the general idea. The core of AI application relies to a large extent to mathematical concepts which are not protected by copyright and are currently difficult or impossible to re-engineer. This core of AI applications can better be protected through legislation for the protection of trade secrets. Nevertheless, if the requirements for a protectable computer program are met, protection for AI core elements may come from legislation for copyright and patent protection. Thus, rethinking AI and software protection means going beyond copyright protection with the aim to achieve the best possible combination of copyright, patent, and trade secrets protection. Since most AI applications and platforms nowadays are currently offered based on open source licenses, this AI and software protection seems to be even more important. Rethinking AI software and online periodical publications, especially scientific publications, become more challenging since AI is revolutionizing online periodical publications across the entire workflow, from content creation to distribution and monetization. AI software applications in online periodical publications moves from a passive tool to an active collaborator because it can supercharge the creative process through at least the following ways. Topic discovery and trend analysis. AI tools can scan online periodical publications, social media, search trends, competitor sites, and academic databases to identify emerging topics, gaps in coverage, and what audiences are genuinely interested in. Generating ideas and outlines. For writers facing a blank page, AI can generate a list of potential headlines, angles, or even full article outline based on a few keystrokes. Automated reporting for data-driven stories. For most online publications, AI can automatically generate short reports by structuring raw data into a narrative. The Associated Press, for example, uses this for quarterly earnings reports. Drafting and research assistance. AI can help writers draft initial sections, summarize long reports or transcripts, and find relevant facts and quotes quickly, saving immense research time. Also, AI helps polish and produce the content once the idea is formed into a draft article for publication. This can be done through at least the following ways: copy editing and proofreading. Tools like Grammarly, which uses AI, go beyond basic spelling to check the clarity, tone, consistency, and grammatical errors, ensuring a professional standard. SEO optimization. AI can analyze, draft, and suggest optimal keywords, meta descriptions, and headings to improve search engine ranking and selection. Generating multimedia assets. AI can create unique images, infographics, or short video clips to accompany articles, making them more engaging and shareable without a large design budget. Transcription and translation. AI can automatically transcribe interviews and translate articles into different languages, opening up a new global audiences with minimal cost. In addition, AI software applications in online periodical publication may be used for personalization and user engagement to certain online periodical publication. This can be done through the following ways: dynamic paywalls and mentoring. AI can analyze user behavior to determine the best moment to present a subscription offer. For example, it might offer a free trial to a highly engaged reader on their third article rather than their first. Personalized news feeds and recommendations. Like Netflix and Spotify, publications can use AI to recommend articles to users based on their reading history, time spent on page, and declared interest, dramatically increasing session time and loyalty. Interactive and adaptive content. Imagine an article that can adjust its complexity based on the reader's expertise. For example, a beginner's versus an expert mode for a scientific journal. This can be done by powerful AI. AI software applications may enhance dramatically distribution and audience growth of online periodical publications. For example, this can be done in the following ways: optimized social media marketing. AI can determine the best times to post and automatically craft multiple versions of social media copy for different platforms. Programmatic advertising. AI algorithms buy and place ads in real time, targeting specific user demographics to maximize ad revenue and to ensure the right promotions are seen by the right people. Smart email newsletters. Instead of blasting the same newsletter to everyone, AI can curate a personalized digest for each subscriber, featuring the articles they are most likely to click on. Regarding efficiency and monetization, AI software applications can be used to help the business side of online periodical publications in ways such as the following: automated content tagging and categorization. AI can read an article and automatically assign relevant tags, categories, and topics, making content management systems more organized and improving internal search. Subscriber churn prediction. AI can identify subscribers who are at high risk of canceling their subscriptions. For example, they haven't logged in for a month. This allows the publication to proactively engage with them a special offer or to send them a "we miss you" email. Sentiment analysis in comments. For publications with active comment sections, AI can moderate discussions by flagging toxic language, hate speech, or spam, fostering a healthier community and reducing the burden of human moderators. And predictive analytics for content strategy. By analyzing performance data, AI can predict which types of articles, headlines, or authors are likely to perform best, helping editors make more data-informed decisions about their content calendar. And I think this is the end of this presentation regarding AI software legal protection. Thank you very much.